Richard Buckwalter, President of the Board of Occupational Therapy. I'd like to call, welcome to our Wednesday, October 24th, 2018 meeting. I'd like to call the meeting to order and request roll.
Sharon?
Here.
Beata?
Here.
Denise?
Here.
Laura? Here. Jeff?
Present.
Richard?
Here. We have a quorum. Thanks, everybody.
Sorry.
Oh.
I never get the chance to introduce myself.
Let's-
Reza Pejuesh, Appearance Board Counsel.
Yes. And yes, board staff we have, Reza Pejuesh, legal counsel.
Heather Martin, Executive Officer.
Jim Posado.
Thank you. And Cesar Victoria behind the camera. Thank you. Welcome, Cesar. At this time, I'd like to make a few remarks, and that completes item 1. I'd like to move to item 2 on the agenda. You have does everyone have the agenda? Okay. Item 2 is the President's remarks, informational. I do have a couple of things that I wanted to mention that took place between this meeting and the last one. On the 29th of September, I was invited to attend the Psychiatric Occupational Therapy Action Committee Steering Committee. That's on September 29th. It took place in Santa Clara, and so I got to meet the steering committee, which included Karen McCarthy, who's at Dominican University, who's the new chair of that steering committee, and some other therapists, half of whom I already knew. Actually, one of my old preceptors was there, so that was very very informative. They're talking about They talked about their relationship with the Southern California Mental Health Network. This is a mental health OT group. There's a smaller, little bit less developed group in Southern California that we're corresponding with, and they were talking with OTAC, the State Professional Association, regarding continuing education and timing it so that it didn't conflict with their spring symposium, because they had already planned something that was fairly close next year to the spring symposium, and I think they're coordinating that, but getting more mental health involvement. And I was very interested in it because it was at the location of I work for Kaiser in Northern California, and that's the only locked psychiatric unit for Kaiser Northern California. I've recently found out they're opening another one in Union City, so there's more psychiatric services in my particular agency where I work, the company where I work, which is going to be good. Anyway, that was interesting to make those connections. The second one is on October 5th. San Jose State University Occupational Therapy Program celebrated its 75th anniversary, and they had a Friday. They had a symposium where Sean Phipps spoke about the history, and Heather Kitching of the OT Association of California gave a brief talk, or introduced herself. They had a couple of courses that people took, continuing education, and it was kind of a reception after that. So we got to reconnect with that program. I'm an alumnus of that program, but it's one of the original 3 OT programs in California. So that was interesting and nice to celebrate. Also, my parents went to San Jose State. They met there, so that was a nice touch for me. No more. I have no more remarks. Moving on to item 3, any other board member activities or remarks?
Conference this week in OTAC.
The Occupational Therapy Association of California Conference.
Yes.
Oh, you don't have your own mic, so we're sharing.
That's okay. Yeah. So OTAC is this week. Starts Thursday night, kicks off, and come see the board. We're presenting Saturday, and come see. I'm presenting Friday, and a whole bunch of people are presenting. So yay.
Did all the board members get an email about?
I didn't send it to the ones that weren't going to be here.
Okay. There's a reception that the board members got invited to, so it just there was an email that came to us. If you're here Thursday night, Thursday after, before there's a movie or something. No, you don't have to register for that. Any other board member comments? Okay. Hearing none, let's move on to 4, public comment for items not on the agenda. I was going to acknowledge the audience, but at the moment we have no audience. So I think we can move on to number 5, the review and vote on the May 31st to June 1st board meeting minutes. Item number 5. These were carried over from last time to correct some concerns about accuracy. Have the board members had a chance to review this revised version?
I just found a little typo on page 3 at the very bottom paragraph. It reads, athletic trainers would be creating a board the manages registration. I think
So
it
it should be that.
should be that.
Any other comments or? Do we have a?
I'll make a motion to, with the minor modification that was made for the spelling, that we accept the minutes.
Second?
So we have Jeff made the motion, Laura seconded. Any board discussion? Hearing none and no public comment, no public to comment. Let's vote.
Sharon?
Yes.
Beata?
Yes.
Denise?
Yes.
Me? Yes. Should I say Laura? Laura? Yes. Jeff?
Yes.
Richard?
Yes. Motion carries. The May 31st and June 1st minutes are approved. Moving on to item 6, that's the approval of the June 20th, 2018 special teleconference board meeting minutes. Any concerns or issues with these minutes? If there are none, do we have a motion to accept these, to adopt these minutes, accept these minutes?
I'll make the motion to accept these minutes.
I second.
Sharon?
Yes.
Beata?
Yes.
Denise?
Wait, do we have to do board discussion and public comment? Well, any board discussion before the vote? Hearing none.
Okay,
Let's
sorry.
have the vote.
All right, sorry, I jumped again.
It's okay.
All right, Sharon?
Yes.
Beata?
Yes.
Denise?
Yes.
Laura? Yes. Jeff?
Yes.
Richard?
Yes. Thank you very much. Now moving on to item 7, the review and approval of the August 23rd, 24th, 2018 board meeting minutes. Do we have any comments on that?
The portion I was present, I saw none to comment on. It was fine.
I had two. There is something on page 14. It's item number 21. One of the motions says that Denise Miller moved to the board support. Denise both made the motion and seconded, and I'm not sure. I don't think that happened. I think somebody else seconded that, probably. Or so we might need to check on that.
So, do you have your minute? Do you have your notes in your packet? Can you please?
Jeff can look at
Yeah. And then on the first page, there was also the, I mentioned, it says Mr. Buchholz reported that he would be giving a presentation for CBOT at the conference. It's also me, Sharon, and Heather. I was going to add that Vice President Pavlovich, and Heather Martin would be giving a presentation for CBOT at the conference. We might not have confirmed you because you were ill during that meeting, and I wasn't able to say, can you make it or not, for sure, but that's what I intended to say. It's not inaccurate to omit that, but if we could add that, that would be good. Should we move on until we can figure that out?
It'll just take just a second.
Oh, okay. Yeah, we can take the time. Are there any other concerns about the minutes that anybody mentioned?
Item number 21. It should be probably like second to last page, maybe. That's why we all take handwritten notes. Okay, how about, well, we'll bring these back to the next meeting
Next meeting, sure. With those changes.
with those changes and the correction.
Sure. And there is a question here on page 2 that we were going to ask the executive officer if we needed a motion on the topic of the referral. And we didn't make a motion at the last meeting because we weren't sure. We were going to consult with you, Heather, and I just wanted to make sure we follow up on that.
Yep.
And then also on page 3, there's a letter to the OT programs and A code of the doctoral program. Those are the 2 items, which I'm sure you picked up.
Yes, I'm gonna report on that.
Okay. So we can maybe follow up on those. So we're going to move item 7 to the next meeting until we get that clarification on that motion and vote. Motion and second. Agenda item number 8.
Is it,
Oh.
President Bookwater, is it the next meeting or the next meeting day, meaning tomorrow?
Oh, we could maybe do it tomorrow. I don't know. It's, whatever they can, whenever, I don't know if they have access to.
If staff lets us know if tomorrow works, great. If not,
Could be,
we'll
yeah.
Report back tomorrow.
Tomorrow sounds good. Yeah, they can let us know. That's a good point. Thank you. Okay, agenda item number 8, the September 5th special teleconference board meeting minutes. It was a special meeting.
I think Richard, is that, we don't call her name that way, right?
Do we have any comments on this? If not, do we have a motion to adopt these
I
minutes?
move that we accept the September 5th special board meeting minutes.
Great.
I'll second that.
Laura seconds. We have a motion and a second. Any board discussion? Hearing none. No public to comment. Let's have the vote.
Sharon?
Yes.
Deanna?
Yes.
Denise?
yes.
Laura, yes. Jeff?
Yes.
Richard?
Yes. Motion carries. Thank you. Moving on to item number 9, discussion and possible action.
I would like us to discuss that first.
Discussion and possible action. Do we have a request to rechange the order of anything in the meeting today?
Yes, did you have a request?
I'm hearing.
Oh, sorry. Sorry.
No, I am.
Oh, okay, I'm sorry. I did have a request if item number 11 could be held over to tomorrow. OTAC and AOTA will have representatives here tomorrow and want to use that opportunity to talk about future legislation as well as report on the 2 bills that they sponsored, one that passed and one that didn't. So I just wanted to thank you for the reminder.
I think that's.
Maybe Sharon.
We'll get the packet for that tomorrow,
Oh, yeah.
since it's not in our,
Right.
there is no tab item number 11, so I would imagine we get that tomorrow.
Right? There's no 11 in here.
Right. There's no 11. So none of us have it.
Could we haven't been told this?
Let's
Heather, Mark,
Yeah.
hi. Do you mind restating what is item 11 that they've asked to hold over?
So item 11 is sort of like a placeholder item so that when legislation is being discussed, if there is something that comes up, it's sort of like a public comment, but it's specific to legislation only so that the issue can be raised and then the board can decide if they want it to be held at a future meeting.
That's why we don't have a tab. That makes
Correct.
sense.
It's a
That-
verbal- it's
that
a verbal
makes sense.
only.
Yeah,
Yes.
that makes
Yeah.
sense.
Very good.
Okay. So, any objections to carrying that over till tomorrow?
No.
Good, great. So we're going to do that. Are there any other items that that's the only item you were discussing that we need to
Well, we were
address?
discussing number 11.
Something else. Okay, so we're moving on to item number 9, discussion and possible action on updated board administrative manual. We've seen this before, and then legal counsel had some additional changes. I do like the new logo. So those board members who weren't present last time, that we did vote on this, the new logo, and I hope you don't mind. I hope you like it. Because here it is already in use. And I think it's beautiful.
I like it.
You like it?
Very crisp. And what we're going to do is start replacing the current logo with sort of the peach background and the three people. Anyways, replace that gradually throughout the website and start using it on the Twitter and Facebook so that we sort of can rebrand, if you will, with the new logo.
Sounds good. And for the webcast, we can show here. I'll just hold up my book for the webcast. That's what it looks like. It's an oval. Okay. All right.
Do you mind if I can?
Take it.
I wanted
please.
to give a little background on this item only because in the August meeting minutes, and I apologize that I was ill and unable to come, that there was a request at that time for the manual to become in track changes. And had I been here in August, what I would have said is in the February version, the manual was provided in track changes. That track changes version was a result of the admin committee, Sharon and Richard and I meeting to come up. Were you in that meeting? I can't even remember. Anyways, my apologies. I don't know. So to make recommendations. So that was brought to the February meeting in track changes version. Then the board voted on that, accepted the changes, also made a few changes at the February meeting that was then presented in the May version. At that time, legal counsel Noreen Marks had remarked that there were some formatting issues. For example, with the revision with the sections cited in the left-hand column, as well as the revision dates. That earlier version, for example, had some incomplete dates. It said like 20XX instead of saying the actual year that the revision occurred. The use of section was presented both with a symbol, with SEC, and spelled out completely. So between the May and August, Noreen and I met to discuss about the change to the per diem policy, which there's information in this item specifically to that. But the rest of the changes were all in the left-hand column, in the formatting of the font size, the use of the symbol for the section, as well as the dates. Those were the only changes that were made, and there was one correction, which had to do with the per diem and reimbursement of travel expenses on approved travel. So there was one correction made that was not shown in track changes between May and August. And even I recognized that the request was for the August version to be, in the August meeting, there was a request for the manual to be presented in track changes. All the changes had already been made. There was not a track change version available. And I would have shared that in August had I attended that meeting. So I just want to kind of give the iteration of where we got to now. So in the May meeting, one of the motions was to have Noreen, legal counsel, and I to meet on those corrections, which we did prior to the August version. And other than what I just mentioned, there were no additional changes, except for there's being one more idea, presented to see if you want to include that, having to do with the per diem, and that's later on. But I just want to get to the manual that's presented today.
Thank you. Any comments on that from board members?
I have a comment. Thank you, Heather Martin, for that explanation. Thank you, Richard and Sharon and Heather, for working on the manual. Since I was the requester of the strikeout version and have consistently requested that and had some agreement from some board members, I guess all I would say going forward, it has nothing to do with any one person, people, anything in particular, other than that's the process of many iterations over many meetings. So if we could just note going forward that any updates to materials that the board has to live by, that are in writing, that are our process, that they would include the strikeout versions all the way through. It's a request that I continue to ask. It's part of a process. I just would hope that there would be some agreement on that.
I think it's a good idea, Denise, and the disciplinary guidelines is something we're working on now. I think we're kind of in the middle of that. Is that something that you might be able to do?
It is in strikeout.
So we'd be able to do that for the disciplinary guidelines.
That's great.
That would be great.
Yep.
Yeah.
It's in that format.
Any other comments on that? I had two small changes. One was there, and Heather's looking over my shoulder and saw it on page 2. The NCART, it's the abbreviations, and it looks like there's an indentation issue in the second column between NCART and POTAC, so that it gets cut off. So anyway, that's just a formatting issue. And then I found one typo on page 13, bullet number 3, where it's under the roles of the board officers president. It says meet and communicates with the executive officer on a regular basis. I think it should just communicate. All the other verbs, everything else there is.
Would you change meet to meets?
Well, no, because look at the other bullets: communicate with, author, approve, chair, meet.
Okay.
So I think that's the only one that's inconsistent with the rest of the bullets. So.
Okay.
The president shall meet and communicate. It's because it's the president shall meet. Anyway.
Yeah. Okay.
And then I was interested in the difference between the 2 weeks for the receipts versus what's later, but I guess we're going to talk about that. You mentioned the board policy. You included some additional documents after this that I just wanted to.
So following the manual. This is the board member attendance form that was previously approved years ago when that section of the manual had a policy established. What does per diem mean? Because the B&P code says you get $100 per diem. What does that mean? There's a board policy that says that means 6 hours of work. So this is that form, except that following that is an extract from the Board of Psychology manual where they have actually expanded their policy regarding per diem. Specifically, one of the biggest differences is not necessarily meeting attendance, but for example, it's enforcement case review, right? So you don't always discuss the discipline in the board meetings. Sometimes you're sent materials at home. Sometimes it's a minor amount. Other times it's not, and it's more of a heavier lift. And I think this policy is the Board of Psychology currently recognizes that throughout the year it adds up, and not that you're all making lots of money on your $100 per diem, but in recognition of your time. That's why this is in here in terms of you guys, evaluating that and seeing if what their policy is more consistent with what you would like this one to be, and if so, then we would need to make the change one more time and bring it back if you're interested. That's what this is about.
Heather, let me ask you a question. They're larger, right? I mean, do they do more disciplinary actions than
Yes.
So their board members spend more time on
Yes.
disciplinary actions, reviewing STIPs than we do.
Yes.
If I may add, though, it's a fair statement to say there's been an uptick in our disciplinary matters, just on balance to the rest of the board. That's a fair statement, right? We've had more teleconference meetings than before. We've had things we've had to take. Yeah. So. Okay.
And the 6 hours is cumulative over
the
month or whatever.
Yes.
And you log it on the form, such as the one we already have.
Yes.
And it includes travel time.
Yeah.
And we have no current provision for.
Well, right now it just says the accumulation of the 6 hours. Sorry, going backwards. It starts on the top of page 21, or sorry, at the bottom of page 21. It talks about time actually spent in the discharge of your duties. That's what the law says. And then if you go to the next page, it talks about the different things, including at the ending of page 22 and top of page 23, it talks about per 6 hours of the actual time spent. And also talks about hours can be accumulated, which is why there's a form to capture those different
see.
events and time spent. I believe also, did you read this? I think we have to do prep. Just one moment, please, I'm sorry. I'm sorry, also so there's two primary differences. One includes the time spent on enforcement case review. It also includes time spent on meeting prep, which is not a part of the current policy.
You're saying the reference document that from the other board references meeting prep time as well.
Correct.
Which ours does not give any consideration for when you send us a packet of
Yes.
agenda items that we're supposed to review and cases we're supposed to read before getting here.
Correct.
Okay.
So then that paragraph is at the top of the third page of the additional items in it's the copy of the Board of Psychology manual.
So we have sort of a broad, in our administrative manual, we have a broad permission for board members can be compensated for actual time spent performing work authorized in advance by the board president. And then they actually spell out this as one of those things, seems like. It's sort of authorized by the...
Well, I'm sorry, just to clarify. So right now on page 22 of our current manual under number 1, it says, shall be paid per diem for attendance at board and committee meetings that they are members. So it's a little bit more limiting, whereas the proposal would include prep time for those meetings as well as enforcement case review.
Right. I mean, item 3, we could include prep time and enforcement case review.
Correct.
Under item 3 as approved.
Yes. Well, it's over here actually in 1 also, right?
Oh,
because
is.
this would have to be changed.
Oh, it would have to be changed.
Right, because it says actual attendance.
Okay.
So if we go beyond 6 hours, we get another per diem?
Well, you would track it until you hit 6 hours, and then you turn in and you get a per diem. So you get the per diem for the first 6 hours, and let's say you had 8. Well, that 2 is going to just kind of carry over till you reach 6 again.
So just to understand what's before us in this piece, in the current version, we come to a meeting, it's tracked that we're here for 6 hours, we receive a per diem check. Are we doing anything different going forward? We're having to track it? We're having to fill something out? Does that go to our 6 hours? Kidding.
So each month I get a big timesheet, and I go in and for the board members only, and I fill it out. So on the meeting days, if you're there both days, you get a mark for both dates. If you're there one day, you get the 1 tick, and then for each one of those throughout the month, you get the $100 per diem. So currently we do that because it's very clear. It's just the board and committee meetings. If you're going to expand it to include meeting prep and or discipline case review, then we wouldn't be able to track and monitor that. I don't know how much time, folks spend. And then for that, you would need to use the form to get your cumulative
But you would
6
still
hours.
track the meetings.
Correct.
We would track the additional time.
For meeting prep as well as discipline
Got
case review, because I'm not going to know, for that committee meeting that's scheduled in 2 weeks, did somebody spend an hour, or was it a big committee meeting with hundreds of pages, and so you're going to spend 4 or 5 hours? I mean, I'm not going to know that. So folks would need to track their meeting prep as well as time spent reviewing the discipline cases.
What does that mean for conference coming
If you
up,
so choose.
Saturday?
That's not a board or committee meeting.
It does say something though about, or is that the, hold on.
I think it's at the end about the membership and attend
Yeah,
affiliation. Page 26, affiliation with other organizations. It does talk about ensure representation and attend other events as.
well, it also says 22, page 22, item 2, board members shall be paid per diem salary for attendance at education and outreach events or events including but not limited to hearing, conferences, or meetings. Isn't that?
I would say so, yeah.
Okay. Do you want to come up with language today that incorporates case review and meeting prep in this language and approve that, or do we want to send it back again and have it come back again?
So the
Or
only
do we
two
wanna keep it
things
as a-
not in our language right now are review of cases, and what's the second thing?
Prep time.
Prep time.
Meeting prep time. And we could borrow can we find something that we can borrow from this psych board language?
Well, I would think, since it was brought to our attention by our executive officer, that she has an idea of how it could be changed. Why don't we just assign it back to her and her staff to come up with a recommendation so we can vote on it and legal, of course. Sorry. We always know after you come up with it, it goes to him first. And then bring it back to us at the next meeting.
If we go that position, it still says in our policy that they would be able to submit for the conference, right?
I would,
It does say that.
So I would say, if we can have some action on what's before us right now for certain board members who've invested time in prep. If we could have retro for the 3 years I was, I'm kidding. Just trying to see if Reza was watching me.
You can go for whatever you want, I guess.
No, but if it does say that, and we want to wait for the next meeting, I'm agreeable with what Jeff's suggesting as well.
I think, just to clarify, what Jeff's suggesting, though, is not relative to the conference piece, because it's already here, right?
That's what I'm
it's-
saying. That's
yeah.
why I clarified. If the
Okay.
conference piece is in it and all that's before us are those other two items, it appears that unless you sense, just from a tactical standpoint, do you sense that we have a lot of cases coming before us before February that we'll be reading outside of this board meeting?
One moment, please,
Thank you.
because I'm not sure. Okay, so I would say with 30 cases pending at the AG's office, many of which were sent more than 5 months ago, and it's sort of the 6 to 9 month mark when we get things, and I would say you'll probably have more between now and February than you would typically, given one, the volume that are currently pending, and two, given the amount of time between, because we're having the meeting in October instead of like November or December, so it's the span of time. If the first meeting is February, then there's a greater span of time when you're not having an in-person meeting.
So would it be a reasonable request if again, following Jeff's suggestion, Heather, I'm sorry to put you on the spot here, but is it a reasonable request that you could bring back some example wording for tomorrow and we could maybe vote by then? Or is that...
I actually have some example wording now
Oh,
based on the
great.
site.
Let's do it.
So
Great.
because
Well, wait, Richard's going a different direction, the president.
because I'm looking at this language and we can actually just borrow it.
Yes.
It's almost there.
It's,
Okay.
yeah.
If we just added to section 3, it says the very last few lines, it says that work include, they're talking at the top of the last page there. It says for board specific work, board members are compensated for actual time spent performing work authorized by the board president. And that actually is already in our section 3 there. And it says, there's a statement after the second sentence on that page says that work includes but is not limited to authorized attendance at events, meetings, hearings, and conferences, exam item writing, exam grading, and enforcement case review. And then the next sentence says preparation time for board or committee meetings, and then it says it's compensated when 8 hours are accrued. Well, we have 6 hours, but we can keep our 6 hours. So why don't we just borrow that sentence? That work includes but is not limited to authorized attendance at events, meetings, hearings, or conferences. Strike exam writing and grading because we don't do that. Keep enforcement case review, and then add as a third item to that list preparation time for board and committee meetings. So we have, that work includes but is not limited to authorized attendance at events, meetings, hearings, or conference, semicolon, enforcement case reviews, semicolon, and preparation time for board or committee meetings, period. And then we can keep that second, and then we could do members, we can keep that next paragraph, members must submit timesheet summary forms for actual work performed outside a board meeting in order to be compensated.
Yeah, we got
Does that,
That works.
I'll make
does that make sense?
Yep. You need a second for that?
Was that that was our discussion?
Well, we need a motion to put. Do you want a motion, Richard?
I mean,
So I make a motion that we accept the suggested wording as just read to us by President Bookwalter, which is identified in the manual in. I don't have a page number to reference. How could I reference it, Reza? What should I call it?
Third page in that.
Last page of the.
I would
Yeah.
suggest taking out in advance on that one also.
With non-substantive
Refer to it.
changes, with non-substantive final changes by executive director and board staff.
For example.
that's good, yeah.
Yeah.
Sorry, there's one more.
An 8. You want to change it to 6 today.
So we have a motion.
I
to-
will amend my, what do you want me to do, suspend it or amend it?
Oh, we can just do that one and then maybe do another one
Okay,
for the sake of the other thing she found.
okay, so then you need.
We have a motion.
Mhm.
Do we have a second?
I'll second.
Beata seconds. Thank you, Denise and Beata. Any further board discussion? Hearing none, no public comment. Let's vote on that motion.
Sharon,
Yes.
Beata,
Yes.
Denise,
Yes,
Laura, yes. Jeff,
Yes.
Richard.
Yes. Heather brought up one thing that we didn't address in that motion, which is that the in advance wording in that section 3 may need to be struck because this I didn't. Board members will be compensated for actual time spent performing work authorized in advance. Because even if we added that language, I would, according to this, I would still have to approve in advance, or the board president would still have to do it in advance. So if we get rid of advance, because then we would just be
where do you see advance?
Yeah, what do you see?
in
that?
advance.
Page 23 of the current manual.
Page 23 of the current manual.
Oh, got it,
Oh.
so it's our own manual.
It's our own manual.
Okay.
Yes, sorry about that. Yes, in that last page, on the last page, it says in advance.
Okay.
Page
thank
23.
You, right here.
So if we could also, if people agree, we could also strike that, the in advance from the
So
administrative.
how will it read? We just struck that whole sentence?
No,
Or-
just in advance.
Okay.
It's authorized.
I make a motion that we strike the word in advance on page 23 of the current board manual.
Second,
I second.
Sharon seconds. Any further board discussion? Hearing none, no public comment. Let's vote.
Sharon,
Yes.
Beata,
Yes.
Denise,
Yes.
Laura, yes. Jeff,
Yes.
Richard.
Yes, motion carries. Great. Any other questions or concerns about the administrative manual?
I have just a request of staff. I recognize we can fill this out manually. This isn't a must-have. It's just a, as technology improves, for you to keep a working file of things. If this form could ever be online so that we just fill it out and it submits, is that ever a possibility, or am I?
I don't think so. But what I can offer is we can request to have a fillable PDF made and sent it to you, so you can save it, you can open it, you can fill it out, save it, send it to us. You still have one there to keep adding to. So then you have that for your records,
Mhm.
and we have a paper.
That'd be great. Again, that request is not a must-have. I know you guys have a lot, but if, as you see fit in your priorities up there, it would be nice.
Yeah, well, because we're going to have the board members mail them to us, because you're going to have to sign unless you want to eliminate the signature. I mean, there's going to have to be sort of.
No, I think the fillable PDF would
Is it-
satisfy.
Can't we do electronic signatures? Is there a way for us to fill out electronic signatures or strike marks or,
Sure. I don't have a problem with that.
then we could just scan it and send it to you, right? Or
just
Or
send it.
fill it out and
Once
send
you
it.
click the
fill
box,
it out and send it.
Yeah.
Okay, that's even better.
but you'd want to save it because it'll.
And do we need any other motions around this? No? It's not changing your form substantively.
I don't do the shit I do when I need to.
Is legal counsel satisfied by the current changes that we just made and everything?
Yes.
No issues? Okay. All right. So we have approved it, right? Okay, so we can move on to item 10. Okay. Item 10, report on legislation impacting the practice of occupational therapy or the board. I would like to hear from our executive officer about this because of the higher level discussions around some of this legislation.
So the first document in your materials is an actual summary of the bill, what it does and what the status is of those presented. Roughly 10 bills, 8 were signed. There are 2 that are dead, one of them being 2386, AB 2386 that was sponsored by OTAC. They do want to talk about that tomorrow. There are copies of the final versions of each of the bills here in the materials. And I want to bring up about the regs, the 2138 regs.
Oh, do you want to just talk about this?
So one of the things that has come up recently is with the passage of AB 2138 having to do with the convictions. Richard had mentioned earlier that the admin committee, executive committee was reviewing the disciplinary guidelines. Because AB 2138 is going to require some regulatory amendments to both some enforcement related regs as well as the application regulation, because the application, even though the majority of people apply online, for those that do fill out a paper application, in both cases, we're going to have to change the wording, and for the paper application, it's incorporated by reference in the regs, which requires a regulatory amendment. So, while I don't want to go into this too much, simply because this is limited to the legislation, I wanted to alert the board to that fact, and I'm hoping that the board would task that admin committee with further expanding their review of not just the disciplinary guidelines, but any other enforcement related regs that may need to be amended so that we can bring something back to the board about this because of the July 1, 2020 effective date, and how long the rulemaking process takes. This will take some time. So that's not on the agenda for discussion today, except that it needs to happen. I don't know if you want to expand on legal's position on that.
There is a centralized effort within DCA Legal, given that AB 2138 is affecting many boards, to kind of coordinate to some extent the changes that boards are going to have to make to their regs in light of the new law. So, and as Heather mentioned, that the timing of it kind of requires that we jump on it sooner than later and identify any of our regs that need changes, work on that language, and really get that ball rolling pretty quickly. Legal, to the extent that there are regs that are similar or the same from one board to another, legal can kind of coordinate the modifications to those regs to ensure that each board is not individually amending its regs in varying ways, to kind of keep some amount of consistency where there already is consistency as needed.
So this, if there's a centralized effort at DCA but we also have to act quickly. I'm a little unclear on should we start combing through our own regs now? Is legal
Yes.
counsel, is the legal department going to do that? How do we?
No, it's going to be
Go
up
about
to
this.
individual boards. You know, you'll be working with me, and I'll be working with legal to. Right now, it's a little bit. It's in the kind of brainstorming stage, I guess you could say, for lack of a better word. That we need to identify all the changes that we need to make, and so I'll be working on kind of parsing out some of those sections that will.
Help guide this board in the changes that need to be.
Yeah, but not only that, but also the what I was saying earlier about ensuring consistency with other boards that have similar regs.
So the sooner we get started, I mean, we have several points along the path where we could make changes in language. If we get started on new language, if we identify the sections that might need to be changed and propose new language, and the DCA comes down later with advice that differs from what we have proposed, I do have a concern about that, but it does take 18 months, to get regs through, and there are opportunities to make adjustments in the language later on, I guess. Is that the thought, is that we would get started, and then at some future review period, if we get a directive that's different from what we have put down, that we would then make that change? Is that kind of
Yes.
how you envision the process?
Yeah, so it's going to be somewhat of a fluid process where don't be surprised if you do make some changes
And have to make more changes.
and then have to make more changes in
Yeah.
light of what's coming down from
That's
legal.
that's our I think we
Or at least you'll make some changes, then you'll have to at least consider additional changes. And part of what I'm talking about as far as the consistency is just some of the stuff that's going to be added to our regs might be brand new, and that's across the board for all boards. And so in those areas, rather than saying the same thing 10 different ways, identifying standard language that the boards can use, those types of things. But I think to your point, we need to start sooner than later to identify the changes and anticipate that there might be additional changes that need to be made as we go through this process.
Okay.
Because of that we might go back and forth, and we might take 2 steps forward and 1 step backwards. That just is even more of a reason that we need to start it sooner than later with the 2020 implementation date of that law.
Okay. Is the board comfortable with delegating that to the administrative committee and bringing that to the next meeting? Is that what we're doing?
Well, I was actually going to ask if we could look to have a meeting the first week in December to do that. And here's why. With the July 1 effective date, going backwards, OAL has 30 working days, which is roughly 6 weeks, to review it. Backing up from that, you have control agency approval. Backing up from that, you have the 45-day public comment, or the noticing the 45-day public comment. You have the board approval. Long story short, we're already behind getting this effective July 1, 2020. And so to the point, while I agree with Reza about legal collectively looking at those things that the boards need to do and recommending language, we already know some of the changes. We know there are changes that need to be to the existing language, and to the point that we can start that process. We have a reg package with 5 other enforcement related changes that we were going to send through the approval process. This is language that this board has all approved. We're basically holding that package to see what the result is from these other required enforcement related changes resulting from the passage of AB 2138, so that whether it's 3 more or it's 9 more, we can add them all to that one big package. I couldn't move the package that's ready forward to the point that changes resulting from AB 2138 could have affected some of those, and they're already going through the process. So we kind of held that up. If we can have the opportunity to review that, incorporate to the extent that it's available from legal, incorporate those changes, then we have something to bring to the board as a total package of proposed changes so that we can start that control
makes
agency
sense.
approval process.
That makes sense.
Yeah.
And I did actually talk to Reza about this approach, about not having two different packages at two different places in that process, but taking whatever results from this new review, and we'll just have this one really huge package.
And so that would be a board meeting of the full board. in December.
Yes, because the board has to
In
approve
person,
any.
or can we do it as a teleconference?
It could be teleconference. Yes, it could be teleconference. It's just that any regulatory proposals, whether I recommend it or legal does, it doesn't matter. It still takes board approval. So you all have to see that package. And what we can do is give you like, here's the before package that everyone approved, and here's the new one. We'll be able to distinguish that so that if there is a section with two changes, we'll be able to clearly delineate, this is the change one is what you approved, August of 17. Here's the new one that's specifically resulting from 2138. We will be, given the complexity of the language, I mean, right now, it's already at over 4 pages of text. And so I know that will expand as we add some things. So we will be very carefully delineate the difference between what's been approved and what's newly recommended language for your consideration.
I like it. It's a good idea.
It's a good process. I mean,
It's a good way.
Yeah, I
Put it
think
all-
it's
do
good.
it all at once.
It sounds like we have a legal obligation to move on this, and we have it's too long till next year. We have all we need is a quorum of the board before at this point, but hopefully we can get all 6 of us. Any so you'll do a doodle poll and try to organize that?
if the board agrees that they agrees with that approach, then yes.
Does the board agree to that approach? Any objection? Anyone disagree with that approach? No.
Sure, I agree.
Okay. All right. So we don't require a motion for that. We just do.
No, I think I'll
Or
take it as
schedule
staff
another board
direction.
meeting. Staff direction.
Yeah. Okay, so, so I digress. That was specific to AB 2138.
Since we're talking about special
Yeah.
specific bills, AB 1659, the Healing Arts Inactive License.
Mm-hmm.
We recently changed our regs to bring our inactive license fee into conformity with the regulation that it be the same as the active license fee, if I'm
Correct.
not wrong. And the passage of AB 1659 would allow us to go back, perhaps, to our old fee schedule or have a different fee schedule.
At least have different fees.
To have
for
different
activating.
fees. And so I'm wondering if we could also ask the staff to look at that, since, if a reduction in the inactive fee is something that we had, and the only reason we changed it was because of the status of law before AB 1659 was passed. It would be nice. Do board members think we should go back to a lower inactive fee? And are you interested in considering that? I mean, we're not voting on that.
We should talk about it.
Yeah, add it to the agenda of a future.
So do you want it on the
Well,
agenda for the December teleconference, or December meeting, which may be in person or teleconference, or do you want to actually push it out to February?
I would push it out because it's
Okay.
there's no
Urgency.
there's no urgency.
There's
There's
no
no time
rush,
limit
right?
like there is.
Well,
In
some
mindful of
folks that are
people's
paying
time in
a higher
December,
fee
don't you
for
think we should
Well,
push
that's
that out
true.
till next year?
This is true.
I agree.
Except for you can then use it when something more.
I think we
controversial
Okay.
need to
is to,
focus on
balance
that
it.
one issue and
We're
not.
all over the
Then
days.
we will bring back language to the first
Procedure.
meeting of the year to return an inactive renewal fee to a lower amount, and we'll get the language drafted for your review, and then you all can discuss and decide what fee amount needs to be dropped in.
Thank you
How
very
about
much.
that?
That sounds great.
Okay.
Thank you. And then we have AB 2221. The only future item there seems to be the OTA, the ratio of OT to OTAs for supervision. The previous, before AB 2221 passed, and there may be more, but there was language about how an OT can supervise 2 OTAs, and then AB 2221 changes that to an OT can be supervise 3 OTAs, and that may require, if I'm not wrong,
No, you're right, yes.
a review, at least a review of our current regs
Well,
to see.
because it says may supervise, and then in the next sentence says, but in no case shall the total number of OTAs supervised exceed twice the number of OTs. So for example, if Richard and I work together, then maybe I'm supervising only 2 OTAs and he's supervising 4. We've had that request before where there's somebody wanting to exceed the maximum because it's stated in the law. That would require a regulatory change, as well as the provision regarding the doctoral degrees. Both of those would require regs too.
And I already had a question of that when I was at the San Jose State 75th anniversary. Somebody already approached me about, does that mean we can start doing a 1-to-3 ratio? Because people were asking, this is Louis Arabi, people were asking him. And I said, I can't speak to that right now, but the law says this and the regs say that, and I'm not. We'll call Heather Martin.
And so what I think it does say you could do is if a person's only supervising 1, somebody else could do 3 instead of 2 and 2. Because if the overall has to be an equivalent of 2 to 1, regardless of what the expansion for an individual might be, that scenario, if there were only 2 OTs and they had 4 OTAs, 3 could be supervised by 1 and 1 could be supervised by the other. Right?
Under the new language, that's increasing from 2 to 3.
Right.
So I think what you're saying, but the numbers would be slightly different. So
Okay.
you might supervise 5 and I'm only supervising 1 because there's
Okay.
2 of us and we can do 3, but not exceeding twice. So
Okay.
you could have
Okay.
5, I might only have 1.
Well,
Regarding the OTD, in the new language of 2570.18E, it does say the board shall define by regulation the doctoral degrees that are in a related area of practice or study for purposes of this subdivision. So that's going to require,
another one.
that's another one that's going to require, right?
Can we go back to the OTA, what you just identified with the numbers?
Yeah.
So you're saying the way the wording is in AB 2221, the way the wording is with an increase from 2 to 3, it's a collective. Because under that scenario you just gave with the numbers, look, here's how I read it. Before I could supervise 2, and now I can supervise up to 3.
Correct.
But what you just identified between that 5 and 1, because between the 2 of you as staff people, you could each do 3.
That's always
How
been
could
there.
that be?
That's not new. That's not new. The change was only from 2, the supervision ratio of 1 OT to 2 OTAs has increased to 1 OT to 3 OTAs. That's the change. The existing language has always said, in no case shall the total number of occupational therapy assistants exceed twice the number of occupational therapists regularly employed by a facility at any one time. That language has always been there. That was not a part of the
Okay,
change.
so then if we're going to open that up, I'd like to look at that language as well. I think that's a loophole.
No, that's what we were just talking about. That requires regs.
Yeah.
'Cause there's-
Yeah.
It says in no case may, but it doesn't tell the profession how they go about that. How do you request approval? There has to be a
exactly.
standard of general application. You can't have this variance where everyone's doing it however they want. If
Have we ever had anybody ask for that?
we've had a few,
You have had a
and
few,
we've said
yeah.
there's no regs defining how to do this.
How to do it. So
And that
yeah.
happens
Yeah.
a lot with hands when you have supervisors that are there and there's several OTAs. And they're like, well, I'm in a room. I could look at 3 or 4 or 5 at a time.
Yeah.
But what was put forth in AB 2221 was 3.
Right, it just changed the supervisory ratio from 1 OT to 2 OTAs. It did increase it to 3, except that the
The reg.
language about twice the number has never changed. That
So
just,
how do we get to an action on that?
you would direct staff to bring language back as proposal. You could talk about how delegating it to a practice committee. I mean, there's a number of ways you could do it. Just recognizing that the supervisory ratio changed, this is still an unmet need, a process, how a facility goes about requesting that.
When does that actually take effect?
January 1st. The supervisory ratio increases January, and the other changes regarding the doctoral degree, that all takes effect January.
Thank you.
So in theory, everyone's going to be functioning in the shades of gray until we fix regs.
Correct. They have been. I mean, in all fairness, they have been, because that one piece, it doesn't really give them a process to go about that.
Other than best
It doesn't
practice.
give prescriptive criteria. It doesn't give really enough information even there for staff to say yes or no. I mean,
Right.
it's just very gray.
Okay.
I think we kind of had this on the practice committee radar,
Mhm.
but we don't have the practice committee up and running right now. In that other section, not the 1-to-2, 1-to-3 ratio, but the how they request approval. So it might be a good thing to have some OTs and OTAs on a practice committee, look at what the implications, how that could work. Do people feel otherwise, or do you agree? Or?
Yeah, I think it needs to go to practice committee.
Get a recommendation?
I agree.
Yeah, so maybe we can get a practice committee together and review this issue, along with a couple of other issues that we have from our minutes. So I welcome this is a good weekend for people going to the conference to try to encourage people to
I might have one or two.
Yeah.
They just emailed back.
I would volunteer to be on the practice committee
That's great.
if that helps you to get something started.
Sure.
I do too.
And I have some suggestions too.
Wonderful. Okay. 20.
So just one other point of clarification, knowing that I volunteered and you're going to be asking people, this will be put together. What is your time frame for when you want something back? Just so I can.
Well, that depends on when the practice committee is able to get together.
Okay,
When
let's.
appointments are made first, and then when they can get together.
Yeah,
Exactly.
so appointments are
Exactly.
made. Appointments are made. Let's just say everything falls in place the way we want it. Ideally, this goes in effect January 1. What do you look? Are you thinking February meeting? Are you thinking April meeting? What are you thinking, Heather?
For the practice committee to provide recommendations to the board. I don't think I'm able to identify time frame. I don't know when the appointments will be made, and I don't know, it's subject to availability. We had challenges, for example, this summer in trying to schedule some meetings, and some of them, one we did a couple, one we did 3 different doodles, and so
I'm going to actually stop. My question isn't to the point of the obstacles. Remember, I prefaced it by everything lined up the way we wanted. So what I'm really trying to get is that it goes into effect January 1. So we probably, I'll just maybe answer, we don't want to go longer than April with some decision out there around this, realistically, right?
yes, recognizing that it's
Because it takes a
Huge.
long time,
Yes.
because then it would go to June, then it, okay, all right. Just gives me a.
Anything else on 2221? Okay. 2386, we know the service credential bill died.
And that's the one they're going to come speak to tomorrow?
Yes.
Kevin? Okay.
24.
Who wants to speak to it?
That was the
Oh.
one we needed.
2483, also antitrust is inactive. 2958, the teleconference bill, the quirk, AB 2958 quirk. Does the DCA have guidance on? Is DCA going to come up with guidance on that, Reza, Heather?
As far as guidance in the form of like a memo or something like that, what do you mean?
Well, this talks about a alternative way of doing teleconference meetings. It looks like
So, my understanding of this bill, it's part of this. We've already been doing it where there's a physical location and folks who can't make it to the physical location call in. Some of the changes from a notice location. Some of the changes in this, as far as the notice location, anyone who's calling in needs to be identified on the agenda as somebody who's going to be calling in and not at the physical location, but you don't have to identify where they're calling from.
Is that the change?
That's one of the changes.
Okay.
so it allows people to call in from a non-notice location. Is that correct?
Correct. So long as it is noticed that they are going to be calling in and not at the
And not a
at
designated.
the
Not a
physical
So that'll be
location.
easier.
One of the
So that would have been,
One of the important changes, though, that's worth mentioning is that at the physical location, it says a quorum of the members of the state body shall be in attendance at the primary physical meeting location. So at a lot of our teleconferences in the past, none of you were actually at the physical location. That was just for public participation and board staff. Under this, in that kind of a meeting, we'd have to have a quorum at the physical location.
so you like, if it was in Sacramento, you'd have to have a quorum in Sacramento.
Yes.
You could have 3 other call-ins.
And one,
Okay.
yeah. But we could still do it the way we're currently doing, because this is just an alternative, right? I mean,
Is it changing?
Yeah. No. This is
it's an optional,
This
an
is-
alternative optional method.
no. I don't think so. I think this is changing
The
the
way
way
we-
we're doing.
So
things.
we can't do could we do a teleconference meeting in December from,
This doesn't go into effect till January 1st.
I see.
So that's.
So
that's
start of
amazing.
January 1st, we can't do what we've been doing anymore.
Well,
No.
you'll have to tweak it a little bit.
Well, it just says
I used to go to
optional, so-
Sacramento all the time anyway, so.
It says optional.
Where does it say?
Alternative
Well-
optional method.
Can you bring?
That's what made me wonder.
Can you let us know that in December, Reza? Can you check
Sure.
on that and clarify that?
We'll ask for a legal memo.
Ask for
on
yeah,
this.
That's just
Thank
an
you.
interesting,
Right.
it's just an interesting word to use.
So
because we don't know.
I would rather you
That's
go
such
through
a-
this.
We don't want to run afoul.
I have one further question, because in the past, because it had to be a notice location
Yeah.
for teleconference, that meant it had to be within the parameters of the state of California, so that way people who would be impacted by the decisions made could attend that meeting at that remote location. If we're able to call from an unnoticed location, does it require you to be within the state of California if you want to participate in this call? So for example, I'm in Washington, D.C. for work, and it's on a date that wouldn't be convenient. Normally, I wouldn't be able to attend that teleconference call, but in this scenario, it looks as if potentially I could,
As long
Do
as
a
there's a
call.
quorum
Good
at the main
question.
site.
as long as there's a quorum at the main site.
Yeah.
Your question is,
This also-
can you call in from out of state?
Yeah, participate in a.
I don't see anything that would prohibit that, but if you want, I can address that in the memo.
Yes,
That'd be great.
right, because, yeah, it also talks
But
about
it's not only
requiring
that, but then it would not have to be noticed location. That's
that's
the
new.
question, right?
Right, it's just saying that you could
Because
be
you
at
can
a.
call it from out of state now,
And
but
it
it has to be noticed.
Exactly.
No, I don't
There's a
think
lot
so.
of confusion with this one.
I was told I could
Not sure
not,
if they're-
if I was out of the state, I couldn't
I mean,
have a
is it
notice location.
optional?
because
Yeah, because
people
California
are supposed to
you
be
could
able to
use
go
two different
anywhere.
notice locations. They can be there as an alternative location.
So thank you. That would be, it'd be great to learn more about AB 2958 and its implications.
I mean,
Moving on to SB 695. Doesn't really anything on any of the rest of these actually.
No, well, for example, on 695, in anticipation of this and how far in advance requests to make amendments to Breeze are made, the department actually took the lead on making changes regarding the disclosure about providing either a social security number or individual taxpayer identification number. So we're going to have to go back and look at the paper application, which is not necessarily a bad thing since we're looking at it anyway to change it for some of the changes for 2138.
Do we currently ask for citizenship or immigration status on our license applications?
No, we expanded it from just an SSN to an ITIN, individual taxpayer
So
identification
to
number.
bypass that.
Yes.
I see. I didn't realize that. Yeah. Okay. That helps me understand what you're talking about.
Yeah, that's.
Because I wasn't sure. Of course, SSN is the.
So, I mean, just a little background.
issue.
Years ago, somebody could apply, but if they were coming from another country and didn't yet have a social security number, part of the rule of NBCOT is that they can issue the visa credential. And so once they passed the NBCOT exam and then they had eligibility, for example, from us to the individual could go take that information and use that to help them get social security number, and then later that was expanded to not require the social security number but allow the individual taxpayer identification number. And this is a little bit more limiting regarding the regulatory oversight of that process.
So we wouldn't really need to change anything, it seems like, because
I don't think
we're ahead
so.
of the game on that one,
I believe we're in alignment with
in alignment.
the rest of the boards regarding this.
How about SB 1348, PAN?
Yeah, what's that?
So that's the bill that is more of a reporting requirements. There is a staggered approach. The community colleges have to start reporting certain data sooner, and then the for-profit schools have a later time frame to come into compliance to provide those specifics regarding, for example, graduation rates, exam pass rates. There's also the one important provision in here that has to do with the schools reporting on their clinical sites. And I believe earlier when this bill was going through the process that was part of the concern because of the challenges that the school have in the clinical placements. Sometimes there's a collaborative sharing of that information, and other times it's very tightly held information regarding where the schools are placing, and this bill would require reporting some of that.
So this was approved, so is this, do you know, had to do with looking at workforce data and getting those numbers that are often missing?
It's not related to that at all. It's
No.
specific to the schools.
This is the bill that we looked at in the Legislative and Regulatory Affairs Committee, and Ada Boone Hurl was involved in making a recommendation. It was the recommendation that we support this bill because it would bring private for-profit schools into line with requirements already in place for community colleges. Most of this was already done in the public college public colleges, but not necessarily private. And the opposition, as I recall, to this bill was a couple of the private for-profit OT programs because they would have more requirements, but they were already in place. The sense was that they were already in place for the public colleges, and that this brought them into alignment and parity.
And so they'll all have to report where their students are at, level 1s, level 2s.
Yes, I was surprised at how much reporting the public colleges had to, that they did all this already, but that was what we learned from Ada.
Okay. Thank you.
The primary data reporting elements are actually on page 3 of that bill.
3?
So and so you can see what the new requirements
Yeah,
will
and
be.
if you see anything that we might need to address when you review that, the bill is in the packet.
Thank you.
Something that we may have missed in the final version. SB 1448 Hill.
This bill, the board was not listed in it. The board's listed on the little synopsis that are specifically regarding those bills that must do that, and that has to do with the disclosure, a licensee's disclosure to their patients or clients that their license is on probation. I only brought this to your attention so that you could see what other healthcare boards are required to do, and so far to just raise that issue, and then if it's something the board wants to look at, then there is you'll have to address that at a future date.
So currently the Board of Osteopathic Medicine requires you to report to your patients that you are on
Right,
probation.
podiatry, osteopath, naturopath, chiropractors, acupuncture, and medical board.
So I have a question. So if we have 2138 where we're having to give licenses to people that we might not have felt so comfortable doing that, wouldn't it make sense then? Because part of our big concern was that these are situations where people are one-on-one in vulnerable populations, and so we would want to make sure that they notify their patients that they're on. So I would think it would be a good thing for us to research, because we're going to be allowing some people that we may not have allowed in the past, which I would have felt was appropriate for us not to allow to have a license, but now we'll be changing that somewhat. So we should probably look at public knowledge as the best protection we can provide.
Because right now they have to report to their employers, correct? And
Yes.
those are the people who are supervising, and there was a lot of pushback before from that. They want to eliminate that requirement. We should probably have a discussion about that.
Well, most employers do a background check, and so they would know as soon as they do the background check that someone's on probation.
Well, now you're
Right.
asking, yeah.
I'm sorry, just to clarify though, this is for requiring them to disclose this to their patients.
To the patients, I understand
Yeah.
that.
Which is
I'm on
another,
probation, so
yeah,
when
I'm
the
on
patient
probation.
comes in, I'm on probation.
Yeah.
And these are also professions that have a lot of private practice, where
Mhm.
OTs tend to work for. There are private practices, but
That's
we
what-
tend to be covered by employers who. Anyway, it's an interesting bill.
Yeah, I'm
Do
gonna
we
take
want
a-
to? So you want to discuss? Sounds like we have some interest in discussing it at a future meeting.
Yeah,
Yeah.
probably should.
We can add that to a future.
We
agenda.
we could also in that discussion, if I'm not mistaken, we could limit the kind of reasons that, the reason for probation that would rise to that level, or would we have to be a blanket if they're on probation? I think they could say if it's on probation for a specific type of thing, then it would make more sense that then that would go to the.
It's also a question of why would the board establish a regulation that is not a required regulation? It's a reasonable discussion to have.
Right.
If we're not, is it an overregulation? Is it an
Sure.
overstepping when it's
Right.
not in the statute? So I mean, we should have a
Sure.
further discussion about that.
Okay.
Put it on an
So
agenda.
we'll bring this to a future agenda.
Yeah.
Just
Okay.
for clarification, this would not be a regulation, it would require legislation, as it was previously before.
Okay.
Does
S-
our,
sorry.
question, does our regulatory language, those specifically say anything in relation to this?
That's what.
No, it does
yeah.
not.
Does not, okay.
Right, so the employer knows, the individual is required to share that with their employer, but the clients or patients they treat don't necessarily know unless they've looked the individual up.
We have information's on our website, right?
Right.
Correct.
I'm not sure how I feel about that.
So moving on, so we can mull that over
Yeah.
and talk about it later.
Yeah.
SB 1480 Hill.
I only put that in there. The beginning of the bill is specific to the other boards, but it also has to do with lowering the number of meetings required for all boards. Like right now, our Practice Act specifically says that the board needs to meet 3 times a year, specified locations. The board typically holds 4 to 6 meetings, more than that in some years.
It'd be nice to get down to 3 meetings
Yeah.
a year, let alone 2. But
Well, but everything else is increasing. The cases, everything.
so would this require a change in our statute also? Because that's in our statute that we have 3 meetings a year. Because this conflicts then. Oh no, we're not one of those boards.
No, we're not on that part. She just brought that for our information too.
Oh, okay, yeah.
You know,
sorry. So we yeah.
Just as a realistic, it could be open to look at, but given what I've read in the agenda and that we're being asked to give dates for strategic planning for next year, it seems like a moot point at this point, and it's just a time filler. So I would say, let's not discuss it any further.
Yeah,
This information.
I'm with you. All right, so does that complete item? Which item are we on? 10.
Actually, one thing I'll just,
Sure.
if we can return to
Sure.
2958 about the teleconference, just
Yes.
significant detail, which you'll have a memo that gives you all the significant details, but it's limited to advisory bodies, so your committees. So if you're talking about meeting in December as an entire board, even though the law, assuming the law would have already been in effect, it still wouldn't cover the board as a whole because you're not an advisory body.
It would be like the
What
practice
about that?
committee or the regulatory committee or one of
Correct.
those, perhaps.
Yeah.
Okay.
Thank you.
Thank you for that. I look forward to hearing more about that. All right, the next item is 11, and we were moving that to tomorrow. So we could go to 12, or we could break for lunch. It's only 11:30 though, so it's a little early, isn't it?
Just a little break.
Let's move on.
I'm not hungry.
See a bio break?
How about like a little bathroom
Bio
break?
break.
Yeah. How about a bio break? Shall we take a 10-minute break
Yes.
Okay.
for? Okay. So if it's 11:30, so we meet back at 11:40. Mindful of the people's schedules, I'd like to get started. Come back from our break. and talk about item 12, which is in the agenda packet and reflects, I think, has a memo from Reza. Reza, do you want to talk about this?
Yes. Okay. So, just a quick preliminary word about that. You've got the memo, and I believe the memo is in the public materials, right?
It is.
Okay. So, just a word on that. That memo is informational. It's kind of an FYI. It's not really giving you any legal advice. It's kind of just informing you that this is taking place, and I'll talk about what this is in a minute. But for that reason, it's not really, being that it's not legal advice, it doesn't really fall into the attorney-client privilege. That's why it's being disclosed and not withheld. Any questions on that?
Nope.
Okay. Okay. So the gist of this is that there was a general business and professions code section that authorized out-of-state healthcare practitioners to come to California and participate in events and actually provide healthcare services under certain circumstances. They had to be licensed, of course, out of state, and they had to follow the procedures in Business and Professions Code 901. 901 has been repealed. In our regs, we had a number of sections that addressed this concept of out-of-state practitioners participating in sponsored healthcare events. Because 901 has been repealed, all of our regs that relied on Section 901 no longer have authority or reference. Therefore, unless we had something else to tie those regs to, we have to get rid of those regs. So 4 of those regs are directly tied to that code section. And then there's another reg that just
Needs to be adjusted.
references. Yeah, we need to delete the reference to Section 901.
No,
So-
I read these regs, but I didn't see which is the one that needs to be adjusted.
First one.
The first one?
4-1.
4116.
Sorry.
Get my-
4117? No. 4116.
All of those.
4170. Sorry, last one.
Oh,
it was the last one. Yeah. Sorry.
And is there? I don't see. I was wondering if there would be suggested language in here, but I don't
It's
see
just
it.
no. I didn't include it in kind of the strikeout underline format. I apologize if that's what you wanted to see, but all it is just striking out the one reference. And
Which is where?
4170A2.
Oh, and also the first paragraph.
Yes. So it'll be 901 at the top, and then
So it would just be section.
no, it is only that. It's that only. It's not A2.
It is what?
The paragraph, the leading paragraph on that page. Heather?
Healthcare practitioners licensed in another state. That
This right here, I think. This one.
CCR 417.
That's I'm sorry. That's just the 40. It's none of the ones from free sponsored healthcare.
Any sexual activity.
So you would delete that that phrase after you would delete or is practicing on a license issued by another state pursuant to sections 901 or 2570.4 of the code.
correct. Just the section.
No,
just
the
the 901.
901.
Not even the word section. We'll change the word sections to section
Well,
It's
and
only
strike
this part.
901.
So somebody could be practicing on a license issued by another state pursuant to section 2570.4 of the
Yes,
code, and it would
yes,
be okay?
yes, because that provision allows somebody with a current unrestricted license issued by another state with substantially the same requirements to practice here for 60 days after they submit an application for licensure. So all of that needs to remain. Sections would just go to section, and the striking of the 901, which is the repealed section.
So it'd just be section 2570.4.
Correct.
And you don't really have discretion over this. It's just it's kind of an administrative thing that we have to take care of. The good thing about it is because of the nature of this, it's a pretty, it qualifies for a section, what's called a Section 100 rulemaking package with OAL, which is an expedited process and pretty simple and straightforward to accomplish.
All right, well, do we have a motion to
Modify?
repeal?
Do we need a motion?
I don't think it hurts. I don't think
Because
we
you
need
said
one.
it's not to our discretion,
it's-
so it's not like we have a choice in the matter, right?
So yeah, that's what you just do is direct staff to make the appropriate changes to the.
I agree.
Yeah.
Okay, so would it be a motion to direct staff? Is that what we're doing, or do we just don't need a motion to direct staff?
I don't think you need a motion.
All right,
I
so
wouldn't
okay,
argue with you. If you
I would
need one.
I'll direct staff to make these changes.
Done.
Remove these sections and remove the reference to 901. Okay. Thank you. That's very clear, and that was the materials were great.
Okay.
They said everything we needed. Anything else any other discussion on that item? People are cool with that?
You meant on behalf of the board, you direct staff, right?
I do.
Yeah.
Did I not word that to your satisfaction, Denise?
Did you wander?
Okay, item 13. Discussion and consideration of the board's ability to accept the surrender of a license. This was a privilege. This is a attorney-client privilege communication. As the minutes we approved earlier said that we held it over until the full board. We wanted to privilege it until the full board could discuss it at this next meeting. So now we're at the point where we've done that, and we want to discuss it. And the question is, can we remove the attorney-client privilege?
Wait, yes.
That's up to the board whether or not to waive that privilege. If you do waive it, it might allow us to discuss this issue a little bit more freely. But it is the board's privilege to waive.
Do we need a motion?
Yes.
I would motion that we agree to waive the attorney-client privilege on item number,
On the memorandum.
on the memorandum.
It's not in the public meeting materials, but
Okay.
But we have it available. Should
Confidential.
Okay. Do we have a second? We have a motion. Do we have a second?
I'll second it.
Have a hearing second. Do we have any board discussion? Hearing none and no public to comment. Let's vote.
Sharon?
Yes.
Beata?
Yes.
Denise?
Yes.
Laura? Yes. Jeff?
Yes.
Richard?
Yes. Great. This talks about the surrender of licenses.
you want to introduce it? And talk a
Yeah,
little about it?
if you could,
Sure. So the idea that what we're discussing is the board's authority to accept surrenders of licenses and some issues related to that. So I think it's not unusual for boards to accept surrenders and to utilize surrenders as an option to either discipline a licensee or to just accept someone's who doesn't want to continue practicing and wants to surrender for whatever reasons they may have. Now, it's not, in our case, it's not quite so obvious that we have the authority to do it. As you saw in the memo, I concluded that you do have, at the least, implicit authority. Your statutes don't expressly say that surrender is an option, but there are references to surrender, so it implies and contemplates that this is something that will be done. Ideally, it would be a little cleaner if it was spelled out. There are some boards that do actually have the authority to do not only revocations and probation, but also surrender. It's explicit, and that's kind of the ideal state of affairs. In your case, I don't think that you're precluded from doing it, but one of the significant issues I raised in this, and before I get to that, let me just say, a lot of this, as you probably noticed, I identified some gray areas, some areas where the authority likely stands for this, but you might want to be aware that somebody could make the argument to the contrary. And so a lot of this is kind of in somewhat murky territory.
Well, can I stop you there?
Yes.
Because, I mean, did people get to read the memo? Did everybody get to read it? And some of us heard the presentation last time, so I just wanted to, because I had a couple questions.
Sure.
There's a distinction in the memo between disciplinary surrenders and non-disciplinary surrenders, which are treated differently. The disciplinary ones are subject to the Administrative Procedure Act, and I think it was under this whole question came up because of a potential case that we had, but that would fall into the disciplinary surrender kind of category, and this gives us an idea that we are subject to the Administrative Procedures Act for those. And the non-disciplinary surrenders, my view is that, have we ever had a non-disciplinary surrender? Where somebody says, I want to surrender my, they just let their license expire.
Correct.
And the only thing, and that's extra staff time for what? Does it protect the consumer to have a non-disciplinary surrender? I don't see that, so, plus that might be someone trying to avoid disciplinary action that we don't know about yet, in which case the jurisdiction issue comes up.
Yeah.
So I'm inclined to, not allow a non-disciplinary, not add a non-disciplinary surrender just because of that, and then the disciplinary surrenders we have to follow this other procedure. It seems like am I understanding this correctly?
Yeah, that's correct. So
Okay.
just on the disciplinary surrender, what I mean by that is, and as I mentioned in the memo, those are my own terms I made up. So I think it makes it easier to talk about this. A disciplinary surrender is, it includes a situation where the person, the licensee, is anticipating formal discipline, and formal discipline has not yet begun. The situation that I think you're talking about that you mentioned would have been a disciplinary surrender. I actually, if I recall correctly, the person was already subject to discipline. It was she was under probation, and had other reasons. So the discipline had already occurred. At that point, she just wanted to surrender her license. I think that was more of a truly voluntary surrender.
She wanted to no longer be on probation, and the only way to do that was to surrender her license.
Well,
Or
yeah,
to complete the terms of the probation,
Complete
which
the
she
term
couldn't
or
because she
surrender.
was out of the state. She
Yeah.
had
Right,
relocated out of the state.
right. So there were options there. One was to look into allowing her to surrender her license. I think a more direct option in that case might have been to just look at whether we could modify her probation, or as you said, just hold her to the terms of her probation. So allowing surrender as kind of a creative solution to that sort of, I guess it was a catch-22 situation there. It might not have been the most direct way to solve that issue.
Well, we had another case where the person orchestrated with the board, correct me if I'm wrong, in order to surrender her license, she had to not comply with one of the terms of her probation.
Correct.
And that allowed the AG's office to move forward with to the revocation of the license, and that's how they ended the probation. And the question is there something in between? The question is, could a surrender process be in between the two, that short of having to do a revocation through the AG's office? This suggests, though, that maybe not.
Well, I'm not sure if I'm missing any facts in the situation you just explained, but where the person needed to not fulfill one of the requirements, that was kind of generating a disciplinary situation in order that we could go and allow the surrender.
But they were already on probation, so they were generating another disciplinary.
Right, and so it still applies. It still would, I'd call it a disciplinary surrender. And in that situation, the AG wouldn't do a stipulation unless there's a charging document, an accusation. So that's what generating that disciplinary scenario allows an accusation to be filed and then go in and stipulate to the surrender. I think there is an alternative to that when you're not in a disciplinary situation. And it seems like that person was, even though they were on probation, that discipline had already occurred and they were on probation as a result of it. At that stage, at that stage, they just wanted to give up their license, and I don't know that there was any other hint that they were going to be subject to further discipline. And if they weren't, then they could consider the voluntary surrender option. Now, the voluntary
Which we don't currently have, yeah.
Well, that's one of those gray areas.
Well, because then that would have been free and clear, and we didn't really want
What's
that.
the difference between voluntarily surrender and surrender? They're both.
Well, so voluntary surrender. The distinction I was trying to make is that you might call. Let's say I'm a licensee and I've done some bad stuff. I know it, and I know the board's looking into me, and I don't want to go down that path of getting formally charged. To preempt that, I can just voluntarily surrender my license. You might call that a voluntary surrender, but what the legal authority was suggesting is that situation wouldn't strictly be voluntary, because there is some discipline that is the impetus for this person to surrender. So it was kind of clarifying that what you might think of as a voluntary surrender might not truly be voluntary when there is the prospect of formal discipline, even if it hasn't been formally initiated yet.
So you want to pulse? You want to pulse on where we're at, or where I'm at? I would say no to voluntary surrender, because then I could just go practice in Nevada or Arizona, and maybe not me per se, but in that scenario, if I were that licensee, I could abuse someone and there would be no record of that in California because I voluntarily surrendered before I knew. And then I could go to 51 other states and keep doing that and practice for 10 more years until I retire. I'm not trying to be dramatic. I'm trying to tell you what specifically could happen. So no loopholes there for me. Secondly, surrender. In the case, I recognize the few cases this has come up, the issue of surrender was the only option because probation hadn't been served in the state of California under the supervision of occupational therapists who could say, yes, your probation is served. Unfortunate for this person, this licensee, because they have really rehabilitated. Trust me, the board really wavered long on that. But the reality of the situation is this. There's guidelines. There's disciplinary guidelines. There has to be supervision, and at the end of it all, the consumer has to be protected. So I say no to all. Thanks for the memo. That's where I rule.
Well, the memo we asked for the memo because of a case in where we had this endless probation situation too. So it seems to me, and we were looking at potential for surrender as a way to get out of that. But really, the solution is to limit probation. To set up a regulation that we talked about. We also talked about saying you can only be on probation for whatever number of years,
right.
And then it's done. That's it. We're not going to have this endless probation situation, and that may be a better solution than establishing a surrender procedure.
Richard.
You know what I'm saying?
Yeah.
That's what I was thinking.
And then secondly, whereas I agree with that, and secondly, where there's not an option to change the way in which we have to rule according to the guidelines, perhaps there's an option in these unlikely scenarios, because all that particular person was looking for, and it made sense to me, was that future people looking at her would know she was rehabilitated a long time, and this was a technical piece. Mm-hmm. So perhaps when there's a technical piece, either the executive director of our board has authority to put some message in there. I'm all for that. I'm not for keeping it away, but I'm not for changing the guidelines around how we get there. But in these unusual cases where they really are rehabilitated, and we know that, I can definitely understand. But I just wouldn't change the guidelines to do that.
I think the unique part of this one too is that the person continued to do all the portions that they could do. They just couldn't work under the supervision of our people. Yet they were working in this. And so, if we could figure out a way where we start getting reciprocity between boards that could say, if they're working in your jurisdiction, can you provide the supervision that we would have required to be able to then make it satisfactory? Because she was doing the work, if I remember right,
Yes,
just was in
right.
multiple other states.
Yes.
She just hadn't been coming back to California because her family had relocated. So, that's really the weird part of this is that I agree. She's obviously, and I think those other boards had to have knowledge that she had been disciplined
They
somewhere
did.
else, right?
Yeah.
They did.
So I would imagine there would have been some oversight on it. I don't know what prohibits us from having some reciprocity of information between boards. Have we ever tackled that? Or, that could be, obviously the associations and stuff talk between, California Board of Occupational Therapy and, the California ACOT and all the different groups are, talk. I don't know why we can't.
They are looking into license portability, which is taking a license from one state and being able to use it in other states. But that's kind of a separate. But that seems to go along with that thinking.
Well, at least, Richard, it could beg the question, since Heather has been on our behalf having those discussions with NBCOT way back when. I know it hasn't been on the agenda for a while, but I would wonder within their license portability if they are addressing any issues of discipline. Does it at least beg the question of NBCOT and to report back to us on it? I don't know.
I think it's a key issue. I think you're right. Heather, do you have any thoughts on this?
I think that it would be good to find out where they're at with the license portability conversations. I would just remind the board that many states still do not fingerprint, and that's has to be a major consideration
sticking
when
point.
looking to somebody coming to the state
Pure
and not
portability.
going through the same process that everyone else does, due to the nature of travelers holding multiple licenses, and that it's time consuming and costly for them getting, for example, these verifications from all these states that they hold licenses. So I would just caution, because there are quite a few licensees, more than a handful, that this board has discipline for. Those individuals have held licenses in other states that have chosen to not discipline, either due to their lack of knowledge, due to their not fingerprinting, or the individuals failing to disclose that. And with this going forward about the voluntary disclosure of convictions, I think it's going to be a bigger sticking point.
So all the more reason to open up the discussion about how they plan to handle discipline, right?
Absolutely.
Well, I, for one, am glad to have this memo because I feel better informed than in that case that we talked about. And now that it's public, now that the board has waived attorney-client privilege on this document, it also can be used to inform licensees or probationers or whatever on where we're coming from if we are not able, if we don't allow them, we don't have a process for surrendering their license. I think this provides some helpful information to their lawyers and to them as individuals. I don't know if people agree with that. So thank you.
I agree with that. I would also say thank you, Reza, for taking the time to educate the board on these matters, as you always do. It's very much appreciated. And please know that the short answers that I give are how to put it into practice in relation to being on this board. So definitely the law is utilized to help, so I appreciate the education that you provide to us.
Thank you, Reza.
So, looking at the agenda, I learned that Jeff is leaving in about, less than 25 minutes. And I'm wondering if we want to go into closed session and have some discussions with his input and move items 14 through 16 to tomorrow. So that we can have a little bit of his... Jeff, are you here tomorrow?
I am. I might even be back
everybody
late
here
this
tomorrow?
afternoon, but
That would be completely fine. If I may just weigh in, I can do it offline, actually, not tomorrow's agenda.
Okay.
Yeah.
I just think that because since part of the closed session is
Yeah,
the
that
executive officer evaluation, I prefer to do it when Jeff, have some input.
Okay.
So if we could move into closed session, adjourn, just move into closed session and move 14 to 16 to tomorrow.
What time tomorrow?
Could I
9:30
ask
9:30.
something?
9:30.
Is it remotely? Oh, you're driving far.
What?
I was hoping that we could start at 9.
We could start at 9. There's no
No.
Oh, because it's noticed on the
It's
meeting.
been
noticed
noticed
at
at 9:30.
But we could do
Okay.
some. But we could do some closed session at 9 if we don't get it done.
You could
If we
do
just
meeting
want to-
preparation at 9 and put it on that.
Are we still on?
I'm teasing.
Okay,
Yeah.
call it to a
I
close
think
meeting.
that the closed session.
Yeah. So we're gonna close. Did I call closed
Well, we
session
got
already?
a couple disciplines too.
Oh, as far as time.
Do we need a motion or?
Two of them are kind of on there. Remove
Yeah,
to
they're just-
adjourn.
Informational.
He's actually called it to closed session.
Yeah, I don't think we need to do a motion or do anything.